Amy Bell back with us for a second session to cover everything that you know around the CDD essentials. Just very quickly before we get started, so Intel, our monthly educational series that Practice Evolve run for the legal community, each month looking to cover topics that would be of interest and value to the legal profession within Australia. And a couple of housekeeping points before I pass on the controls over to Amy. Please do use the Q&A session at the bottom of your screen if at any point you have questions for Amy. We will save all of the questions until the end. And I've already got a few submissions during the registration. So if you have submitted a question already, just keep an ear out, stay until the end. We will get that answered for you. Because I always do get asked, yes, this session is being recorded and yes, it will be made available to you on demand, likely early next week. So just keep an eye out on your inbox for an email from Practice Evolve. Otherwise, it will also be posted on our LinkedIn page as well as on our website for easy access whenever you need to reference back to this. And finally, do enjoy the session. We are glad to have you here with us. Amy, I'll pass on to you quickly. For those of you who are new here, I'll just get Amy to introduce herself very briefly before we get stuck into all the good stuff. But Amy, over to you.
Amazing, thank you. Hello, everybody. I hope you're having a great day. My name's Amy Bell. I'm a solicitor, qualified in the last century, 1999. I qualified, so I've been a solicitor for about 25 years. And for the last 20 of those, I've specialised in anti-money laundering and compliance in the UK. I'm the founder of a business called TL Compliance, which is founded to help law firms with all of the rules and the regulations that they have to follow in the UK. And I'm just in the process of launching our new business here, which is AML Sorted, which is also here to help law firms with all the rules and regulations that they're going to have to follow when tranche 2 entities are brought within scope of the AML legislation. I'm also a volunteer at the England and Wales Law Society. I chair their money laundering task force, which means that I don't just kind of get involved in the practical side of helping people write policies and procedures. I also get involved in the writing, the guidance, and lobbying on legislation and supervision on behalf of the Law Society, which means I understand the background of where it all comes from. Every time they want to change the law, then I'm involved in the conversations about understanding what they're trying to achieve with the law. So that gives me a kind of interesting perspective that as a practitioner I didn't get, as running a CDD team, running an AML team I didn't get, but that political side of it. And AML is very political, is very influenced by politics. For reasons we might come on to a bit later on. And then the last thing to know about me is I am a geek, which means I wrote a textbook, which is called Solicitors and Money Laundering. It probably should be called Solicitors and Anti-Money Laundering, but there you go. I co-wrote the 4th edition. I'm just in the middle of writing the 5th edition. And also a book called Compliance That Works, because I've been working in compliance, as I say, for 20 years, and quite often when people struggle with compliance, they have very similar problems. So I've written a book about how to build compliance programs that work. So that's my bio. It's very nice to meet you. I'm currently in Sydney. It's my 6th trip over. I'm here quite often these days. And I have made it my business to understand what is coming for you guys in legal. We did another session, which if you've not seen, that is available on Practice Evolve's website. I think that's where I saw it, where you can have a look at that one. That was, you know, the kind of what's coming framework. We're getting into some of the practical nitty-gritty today, looking at what you're going to have to do on a case-by-case basis with your clients. So I think I promised to cover today, when the slide moves over, it will do in a second. I promised to cover what steps are involved in carrying out client due diligence. What is client due diligence even? What is this concept of client due diligence? I'll break that down into its constituent parts, which is essentially verifying the identity of a client, understanding the purpose and nature of the business relationship, conducting ongoing monitoring, and probably you're getting lots of emails from providers of software that say that they can help you with AML. help you meet your requirements. For many of you, you might already have some software that can be used to fulfill part of this client due diligence obligation, especially if you're doing verification of identity for property work. So we'll talk about electronic verification, how it works, what all the different features are of it, so that when you're getting these conversations in the diary with people, or people are ringing you up saying, are you looking for a solution, you're a little bit better informed about what they can do for you and what questions to ask. So let's start at the beginning. What is client due diligence? Okay, so just to recap, if you weren't here last time, anti-money laundering is the business of putting policies and procedures in place to try to prevent criminals from accessing our services for the purposes of money laundering or terrorist financing. So how we do that is we create policies and procedures which require us to obtain certain information from a client that do one of two things. Number one, it either puts the criminals off, so they go, oh, I'm not giving you all that information. I don't want to get involved in that. Basically scares them away. Or alternatively, you've got information that you can gather, consider, and if there are any suspicious circumstances from that information you've gathered, then you're going to have this reporting obligation to report to AUSTRAC suspicions. Now, that is a very, in 2 sentences, about 10 hours worth of content in terms of teaching, but that's just the kind of brief headline. The whole point of client due diligence is to gather information on which you might become suspicious, because the whole point of the AML legislation and the reason that there's this suspicious circumstances reporting in is because ultimately what law enforcement want is the information that you might come across to help them build a case against the criminals. So it's useful to understand the why we're doing it at the very, very beginning, because it can feel tick boxy. It can feel like it's just a process and you tick some boxes. Certainly, if you've ever been due diligenced, if you've ever instructed, for example, or opened a bank or instructed a foreign lawyer, you may well have been through this client due diligence activity where they say, oh, well, I want a copy of this and I want a copy of that, and I want you to go on this link and do this thing. And it might feel very kind of processy. And it is processy for reasons we'll look at a bit later on, but it's important to bear in mind what we're trying to achieve with it. So due diligence can be the activity of due diligence, gathering information about the client, is firstly about spotting money laundering, but also preventing fraud. So do we know who our clients are? Are they real people? The criminals will often try to hide behind front businesses or trusts, and so it's not just when we're dealing with private individuals we want to know, what they look like, get a copy of the passport and a utility bill to know where they live. We also need to establish the identity of an entity to make sure that we know who's behind it, so the criminals are not kind of trying to disguise themselves behind these entities. And that's going to be really important in Australia because you've got such a lot of trusts, legitimate trusts. No one's accusing anyone of money laundering in those trusts. But what we do know about the criminals is that they will try to abuse trust vehicles for the purposes of hiding the ownership, that distancing themselves away from the ownership of the criminal property, so that then they can launder it. So your first bit is who we're acting for. Make sure I know who they are, make sure they're not made up, make sure they're not hiding. The second bit is why are they doing what they're doing? Do we understand it? Does it make sense to us? Is there a commercial reason for this? Is there a legal reason for them seeking our advice? Here's the reality. Criminals, when they instruct a solicitor and they're wanting to launder money, there isn't really a legal reason for doing it. There isn't really an economic reason for doing it. There's not really a business strategy reason for doing it. They're doing it because they want to add a layer of a transaction, and they do that loads of times so as to disguise the origin of the money, to make it basically very difficult for anyone to unravel. And so a lot of transactions that fronts for money laundering really don't stack up. They just don't stack up. They don't make sense. Now, there's actually quite a lot of transactions that a lawyer might be involved in that don't have an economic purpose. So, or really a legal purpose. So, for example, if we're putting a property into a trust so our children can benefit from it, and that's tax efficient to do it that way, then there might not be a legal need to do that. There might not be a commercial reason to do that. We're doing it because we want to gift this property to our children. So just because it lacks an economic or legal purpose doesn't automatically make it money laundering. And then the other thing to know about criminals is that they quite often pounce last minute. Very often when we do see money laundering through law firms, the criminal is actually going to kind of reveal themselves much later in the process. It won't normally be at the very beginning. And so for that reason, part of client due diligence is keeping an eye out as you go in, just in case something changes, because in fact, that's what the criminals will do. They'll present something that looks very ordinary, very sensible, all check out. You'll be able to prove it all and everything. And then if they're really wanting to do money laundering, they'll probably change something like the funder, the person introducing the funds last minute, and hope you've not got time to check them out, and so you won't spot it. So there is this obligation to do ongoing monitoring. So the steps for client due diligence, when we kind of convert all of those to actual activity that you're going to have to do, number one, you're going to need to identify your client, which means obtaining information about their identity. Usually this is in two parts, which we'll kind of examine a little bit, but just suffice to say for now that the person or the entity exists, and where we can go to find out something about them is usually the standard. Now, one of the questions that I had for this session that came through, thank you very much for the question, was where can I find the rules about all of this? The obligation for client due diligence sits in the legislation, but there currently aren't any kind of prescribed rules that say you must get a passport, or you must get a utility bill, or you must use this kind of software. That there probably will never be rules that are that prescriptive. There's likely to be guidance issued that will explain to you how you can meet what the law requires, but it's unlikely to be as detailed as you definitely need this. And that's because AML is fundamentally risk-based. So it will change from client to client. So if your client is a private individual, the identity of that person is likely to be their name, their address, the date of birth. That's the information that you're going to want to gather. If your client is a company, you're going to want to understand, who that company is, where the registered office is, who's involved in it in terms of got power and control, understand who the directors are, understand who what's called the ultimate beneficial owners are. So an ultimate beneficial owner is basically somebody who has the benefit of owning the entity. So it's a term that we use when we look at non-natural persons. Non-natural persons is the language we use in the UK. It's a bit of a weird language, isn't it? It means non-human clients, so entities. All right. So you've got limited companies, you've got listed companies, you've got trusts, you've got charities, you've got partnerships. There's all kinds of different entities. Okay, and we know, we're lawyers, we know that somebody's going to have a beneficial interest in that. Somebody owns it ultimately. From the money laundering point of view, or preventing money laundering point of view, we're specifically interested in what we call the ultimate beneficial owners. So these are people who've got a significant shareholding or a significant amount of the power. And by significant, it's 25% or more of the power. And that could be voting rights, it could be shares, it depends on the makeup of the entity. Everybody might be jointly and severally, so there's no real shareholding. So everybody has got a beneficial ownership and equal power. It's about understanding the power behind it. Now, internationally, there are some different standards in different parts of the world. Most of the world is the same as your standard is going to be, 25% plus. But you might have, I think one of the Middle East countries has got 10%. I think Germany might be moving to a 10% one. So yes, it varies around the world, but generally we're into people with more than 25% of the shares, and that's generally because they've got quite a lot of influence to get stuff done. So that's why we have the boundary there. So identifying who those beneficial owners are is in the event that you're dealing with an entity is going to be important. Now, that's the first step. Once you have that information, once you've identified the relevant information, then you need to verify it, okay? So, which basically means proving that it's true, getting some sort of proof that what you've been told is true. So in respect of a private individual, if you said to me, Amy Bell, prove that you're Amy Bell, please, I would probably produce you my passport that says Amy Bell on it and a copy of my electric bill that says Amy Bell lives at 21 The Moorings, okay? And then you would know who I am, you'd know my date of birth, you'd see some official proof of that, and then you would know which door to knock on to find me, traceability of this person. So that's the verification for an individual. For a company, you're going to get some registration documents probably. You might want to verify individuals involved. And don't forget, when it comes to ID and V, I have mentioned it kind of a couple of times in passing, but if you learn nothing else from me today, please learn this. What client ID is simply about traceability. Please don't confuse that with preventing money laundering. Here's the thing, when I explain this to you, it'll make loads of sense. Criminals live somewhere. So just because you've been able to get a passport and utility bill from them does not mean they're not a money launderer. What we've seen in the UK, we've had this legislation for 21 years in the UK, we have come across people all of the time who think that money laundering checks are just about passports and utility bills or an electronic check proving someone's identity. And then they forget about everything else. You don't prevent money laundering by establishing where someone lives. This is just about traceability, which door to knock on to find them, and preferably a picture to circulate. Now, I did mention that there's unlikely ever to be rules that say you must get a certain document. And that is because when you try and think about the variety of ways in which people can prove who they are, there's lots of different ways they can do that. Probably, certainly in the UK, 85% of people have got a passport and a utility bill. What we find in countries with a much larger geography like yours and America, lots of people don't have passports. So they don't necessarily they might have a driving license, might be able to use that. But there's the law and the rules that go with it are usually not prescriptive enough to say it must have a picture on, because there's plenty of people that don't have a document with a picture on that they can give to you. So they can't make it prescriptive, because then what that does is it prevents access to the financial system to certain people who don't have the normal documentation. So most of the time, you'll be fine having an internal policy that talks about either using a VOI check for identity verification of an individual, or downloading documents in relation to a company and getting some personal information and verifying that for ultimate beneficial owner, for example. But it'll be up to you, which means that if you've got a policy that says, we're ordinarily going to use this search service, if it doesn't work, the person can't pass at using that, then it's open to you to think of other things. I'll give you a really common example. People that are in aged care, elderly care, won't necessarily have a need for a passport or driving license, and they won't necessarily have a utility bill because you just pay one fee to live where they live. And so you might get proof from someone, the company that they're paying, that person's there. It's about knowing where to find them. And in real life, this has happened to me in the past, where we've acted for an individual. We've done the identification verification. We got hold of a passport. We got hold of a utility bill for this person. About 6 months after the job had finished, we got a phone call from law enforcement, from the police, saying that person was a fraudster. Please, can you tell me what due diligence you got on them? And particularly if you got something with a picture, because they wanted to circulate it around the local area. Has anyone seen this guy? So, that's what they use it for. It's nothing to do with preventing money laundering. Where you prevent money laundering in CDD, in client due diligence, is about understanding the nature and purpose of the business relationship. Now, this is an incredibly vague kind of step, which is quite detailed. I didn't move my slide on then. I told you everything that was on that slide and didn't move it on. I'm on this one now. So, nature and purpose. In the UK, it's purpose and nature. I don't know why it's the other way around. I really don't. But it means the same thing, right? does it have a legal purpose? I've already kind of gone through that. Or does it have an economic purpose? The lack of which doesn't automatically make it suspicious for money laundering, but you do need to understand the rationale behind why someone's doing what they're doing. Why are you coming to us? Does that make sense? Because here's the thing, criminals don't have a great rationale for it. They might make a story up, and they probably do make a story up, you know, but if it just smells funny, it's just like, I don't think I would do it that way. That doesn't make any sense commercially. In fact, they're making it worse than for themselves. Those kinds of things, these things could be there's clues that you could be looking at money laundering. The other thing to look out for in purpose and nature is about the deal itself, or something about the client. So, you know, when you're thinking about your identification, verification of this client, you're getting to know this client, KYC, know your client, something just doesn't add up. So a company that is dormant, who is buying an asset, for example, how are they paying for this? You know, it's been dormant, they've not done anything with it, or it's brand new. How are they doing this big deal when it's brand new? Something unusual about the client or unusual about the deal. Is it massive? Is it unusually massive for this client? Is it very complex? There's lots of parties involved and lots of moving parts. Does it need to be that complex? If not, is it just that they're trying to layer and bring up lots of parties in to really disguise what's really going on? So for those things, size, complexity, you look at what's usual for that client. So, you know, in some of the clients that I have, big international firms, they will do big deals, and they will also do complex deals. They won't be unusual, though, for those clients to be like, yeah, that's how my clients do stuff all the time. If I was on the high street, a local lawyer, and I got a really complex, high-value job in, I might, this is, yeah, why have you come to me? I mean, literally, why have you come to me? We had this once. So I'm from Manchester in the UK, which you probably do know is in the middle of the country. And we had a client from Newcastle, the very top of the country, who was allegedly going to buy a £67 million property in the south of the country, but instructed us in Manchester. And we were, we were a national firm, but we weren't known for doing that kind of luxury end property stuff. So we're like, why did you come to us? That's really weird. Why have you come to us? How did you find your way to us when you're from Newcastle, you're buying in Berkshire, and you're coming to us in Manchester? It doesn't make any sense. What's the purpose? Why are you here? It was a fraud, by the way. I've got a whole other story about that. They gave me a passport. It was certified by a vet. I'm like, what do vets know about AML? Nothing, probably. So why do they know why they're being asked to certify it? It had a shadow under the picture, as if somebody had blue tacked a picture on the top. And on the bottom of a passport, I've got mine here, but I better not show you because we're being recorded. But on the bottom of your passport, it's got all those little arrows on the bottom. That's called an MRZ code. There, you'll see there's a letter M or F to denote gender. And this client was Miss Alexandra Raffington Fairmont. She didn't exist, so I'm not breaching any confidence by telling you that. It was a made-up name. But on the passport, it said it was an M to denote gender, and obviously Miss Alexandra Raffington Fairmont, we weren't expecting the gender to be M. So we challenged that, they disappeared. It was a scam. But the thing that alerted me to the scam wasn't even the passport, it was just that it was weird that they would come and instruct us to do that. The baddies will do that, the criminals will do that. They will look for a law firm that they think won't spot what they're up to. So yeah, my commercial property department, very excited about it. They're like, oh, look at this big instruction we've got in, Amy. And I had to say, so I'm really sorry. No, you can't do it. So yeah, they weren't too happy with, but when I explained to them why, they're like, oh, great, thank you for not, exposing us to that. Now, purpose and nature, as I said, vague concept, but it really is where source of funds, source of wealth lives, okay? The only way you prevent money laundering, remember, is not by passports and utility bills, it's by not moving dirty money. And the way we do that is we get a good idea of what the assets are and make a decision, make a judgment about whether we think they're criminal or not. Okay, that's the whole point of this. For you to look, get the information in, consider it and think, do I think this is dodgy? If so, I need to tell someone about it. I mean, that's again, another few hours worth of content in a sentence, but that's basically the headlines of what we've got to do. Now, let me just say at this point, I'm going to caveat this next bit. The extent to which you will be required to do source of funds, source of wealth will depend on what you're doing, who you're doing it for, and the approach that your regulator takes to their expectations. Obviously, I can't tell you specifics because, you know, it's going to turn on its fact of who you're doing, who you're looking after, and what you're doing for them. That's about in-scope, out-scope work, which I think there's a question about it, so we'll cover that at the end. But the regulator piece is really important. If I can share with you what we see in other parts of the world, so I can kind of manage your expectations about what the kind of toughest standard to meet might be. In the UK, if you're a property lawyer and you were doing a residential conveyancing, it wouldn't be unusual for you to ask to see 6 months bank statements for any funds that are being introduced by the client into the deal. We obviously wouldn't ask for bank statements from the lender because we're happy the lender's got the money and that they're not money laundering. But the risk is that the client might be money laundering, and so we might ask for proof of their funds, and we might make a judgment about how they've been conducting themselves with that money over the last 6 months. We are very much in the UK being pushed to meet this standard, questions being asked if we're not, and we have pretty much the same wording you've got. So our guidance and our regulators have over time iterated our guidance to get us to a place where they expect us to evidence source of funds, source of wealth. Now, in Australia, we're at the very beginning of this journey, okay? Obviously, the banks have already had this purpose and nature and purpose language for quite a while. It is not visible to me yet what the expectations of your regulator is going to be. So AUSTRAC, what are they going to be expecting? When will we find this out? We will find it out, hopefully, when AUSTRAC either publish a sectoral risk assessment, so a risk assessment specifically for the legal sector, or in guidance that they issue sector-specific guidance. Certainly in the UK, there is some sector-specific guidance, which is approved by the Treasury, so it has kind of the force of law, as in you're expected to follow it. And in there, that's where we get this wording around evidencing source of funds, source of wealth. So there is a difference between establishing the source of funds and source of wealth and verification of the source of funds, source of wealth. Establishing means that you understand it, you've asked questions about it, you've got an answer. Verifying it is seeing some independent proof of what they've told you, which is where bank statements might come in. So I'm letting you know that they could read into nature and purpose, that they expect you to get evidence of what you're told about source of funds, source of wealth. We will only know that when the guidance comes out. When is the guidance going to come out, Amy, is your next question, isn't it? Good question. When I'm in Australia, I speak to lots of people, try and find out the answers to these things. Last I heard, it could be towards Q3. And that would make sense to me, that it would probably be September time, at least September time. And the reason I say that is, whilst we do have the law that establishes that law firms are going to be brought within scope of this regime, we have just closed, just over a month ago, a consultation, or AUSTRAC have just closed a consultation on the rules, the Attorney General probably, on the rules, which is the second bit of legislation we need to know what we need to do. And then once they've got the rules ready, finalised, then they're in a position to write the guidance. So it's kind of, the longer one bit takes, the longer the next bit takes. I would expect certainly by the end of the year we would have sector-specific guidance, because that's only giving us 6 months to get ready then. So hopefully we will get it. And it's then that I'd be able to tell you what you might need to do for source of funds, source of wealth. Here's why that policy I've just outlined to you in the UK has kind of grew up, okay? Because we're the same as you. We haven't got specifics. The guidance doesn't say you must get 6 months bank statements. What it says as a compliance officer responsible for figuring out what your firm's going to do, you need to decide what the policy is for your business to follow. Now, criminals, particularly in property, we know that's high risk. Your national risk assessment says property is a vehicle of choice for the criminals to launder money. And we know that when they're trying to do that for the purposes of money laundering, they're going to be moving money around very quickly. Criminals don't leave pots of money hanging around because it can be confiscated. They like to add layers to it to disguise it. So if you're going to ask for 6 months bank statements and the money has just been sat there, or they've been saving $1,000 a month towards that pot, and that's how they've accumulated it over the last 6 months, that doesn't look like a money launderer. Remember, what you're doing here when you get this information is, do I think this is a money launderer? Am I suspicious about it? So once you've got a period of time of data, you can make that judgment. You just see one bank statement with the money that they're going to use for the deal in there. That's just telling you they're good for the money, that they can afford it. It's not telling you anything about how they've been conducting themselves. And so that's how this period of bank statements has grown up. To contrast source of funds with source of wealth, source of funds is the money they're going to use for the transaction itself. And as I say, I would look backwards and have a look at how that money was accumulated, what they've been doing with it recently. Source of wealth is, where did it come from in the first place? Now, there's loads of sources of wealth. And what we might say in an AML sense is a source of wealth doesn't necessarily correlate with what a client thinks a source of wealth is. So, for example, I've just bought a house in the UK. I had to put, I don't know, 60-odd thousand pounds down on it. And the money came from a variety of sources. Now, it all ultimately was waiting for completion in my savings account. So if my lawyer had said to me, can you please show me your source of funds? I would have shown him my savings account, which was where I had the money for the deal. And I would have given him a period of time. He asked for 6 months. I trained him, so I'm not surprised he asked me for 6 months. So I gave him 6 months. He said, Amy, if you don't do it, you're going to shout at me if I don't make you do it. So I'm like, of course I'm going to do it. I'm very compliant like that. So I gave him the 6 months. And what he said to me is, what is it, Amy? What does it represent, this money? And I said, well, it is in my savings account. And because AML is my thing, I know that he needed to know what pots of money went into that savings account to make that 60-odd thousand pounds. And so it was surplus from income, savings every month. I saved a bit of money every month, but I didn't save all of it from that. Who can save 60 just from a bit of surplus money? Not really. It's a lot of money to accumulate. But I had some profit from the businesses. I had two lots of money from after people had died. So my mum died, bless her, and so I got the rest of her estate, or half of it. My brother got the other half. And then my husband's grandma died, and when his mum got some money, she gave him a share of it. So pretty complex, if I'm honest. It came from all over the place, this money. Now, happily for me, my lawyer didn't feel that he had to prove what I told him about the source of wealth. He was happy. He felt the risk of what I was doing. He didn't feel he needed to dig that deeper. But had he have felt I was super risky, he might have asked for proof of everything I've told him. So he might have asked for, can you show me your accounts to see that your business actually does make a profit and therefore you'd have this surplus. You might ask for my current account to say, let me see what you spend every month and whether you can afford to save anything. He might have asked for a letter or some proof from the bank that the money came from my deceased mum's bank account. I would struggle at what we get from Mark's mum from grandma. That would be a challenge. We'd have to get the transfer from Mark's mum's bank account into ours to be able to show that, because there'd be nothing official about it. And this point actually is a really important one. Verification, we usually ask for independent sources. So my savings account, my current account, my letter from my company accounts, the letter or something from the NatWest Bank as I closed my mum's bank account after she died. These are all independent of me. I haven't created them. Verification should be independent as far as possible from the client, so they can't just make it up. But it's not always possible to do that. And so sometimes we have to get explanations from the client, like for the pot of money from Mark's grandma. We would have had to have looked at the independent verification from Mark's mum and seen that Mark's mum got a letter from the solicitor saying, here's your share of the estate, and then that she did a check to us. We could have done that independently. but also just asked her to confirm that she paid us for that reason. So yeah, verification should ideally be done independently, but not always. It can't always be done like that. Now, you might be sat there going, Amy, why have I got to do all this? Surely the bank are doing it. I'll be back in one. Apologies, I've had it. This, can you hear my croaky throat now? Hopefully I'll go in a minute. I've had a cough for ages. I haven't got COVID. It just won't go. Sometimes my voice just goes. It'll come back in a minute. See, there we go. We're nearly recovered from it. So you might be thinking, why we got to do this when the bank is doing it? The bank absolutely is doing this. They've had that obligation for a lot longer than we have. But this goes to why we have AML and why the lawyers have been brought within scope. I said to you at the very beginning, the purpose of AML is to identify intelligence that law enforcement can use to prosecute the baddies, the crooks. The banks have been looking. The banks will report what they see, but there are more players in the financial markets that see a different view, that have different information, that could spot the criminals. So basically, it's all the eyes on the prize, as many eyes as possible, trying to root out this money laundering is the idea. And that is why, even though the bank are checking, there's nothing in the law that says you don't have to check. In fact, it's the opposite. The law says you can't rely on the bank checking source of funds, source of wealth. You can rely on other entities. And again, the devil will be in the detail, and we need the rules and we need the guidance. It's likely you'll be able to rely on another regulated entity for the ID documents, for the verification of who a person is, to make sure that they exist. But this bit about purpose and nature, as far as I know, nowhere in the world can you just say, oh, well, the bank took the money, so I'm not going to worry about it. And that also follows that just even if you're not touching the money, it doesn't necessarily mean that you're not exposed to the AML regime. The exposure to the regime is about you participating in a transaction normally, and you don't have to touch the money to do that. Certainly, if you look at an American law firm, American law firms don't tend to have trust accounts, which means that they don't tend to accept money. If they do, it goes in escrow, or a third-party provider will manage the money for a deal, or it goes directly between the parties. So they don't have a trust account, so never touching the money, but they could still be exposed to AML if they are. If you look at the wording of what a designated service is, it's in the planning or execution of a transaction. So you don't have to touch the money. So please don't think you get to skip this step if you're not touching the money for a transaction. You would still need to understand the purpose and nature, and that might mean understanding the source of funds, source of wealth. So yeah, it would be really great if you could just rely on the bank, but philosophically, they just want as many people trying to root out this. And in fairness, they're right. There is information that we would have, conversations we would have with a client about a particular transaction that the bank is never going to have with them. The bank's just seeing the money moving. We've got the context. The accountant has the context. And that's what they really want you to look at. So moving on, ongoing monitoring. So we've done identify verification. We've worked out the purpose and nature. Quite a lot of that activity is done near the beginning. Some of source of funds, source of wealth might be done nearer to when the transaction's actually taking place later on. But most of the time, we're setting this up for activity at the beginning, for file opening activity. You're going to say to a new client, when they come in, bring your documents, or you're going to put on your new client opening process that they go onto a website or they go onto an app and they do the client due diligence. All at the beginning. And you're probably going to ask questions about how they're funding it as well at the beginning. As I said at the very, very beginning, the baddies will pounce later on. So it is really important when you're building your program to build into it ongoing monitoring. And now the law requires ongoing monitoring, but you need to figure out what that means in practice for your firm. For law firms, quite often, that would mean at a minimum, just before you do the thing that could be money laundering, check that everything's still the same. Okay, that one of the things I do in the UK, or we do, Teal does in the UK, is we do the independent audits. So all of you, if you're going to be in scope, will need to have an audit every 3 years. And that's mostly what we do in the UK because it's quite a mature industry. And so everybody's got policies and procedures. So when we are auditing them, we are looking to see, did the ID&V, did they establish the identity of the client? Did they understand purpose and nature? And did they conduct ongoing monitoring? Now, the problem with ongoing monitoring is if nothing changes, how am I going to see it on the file? If something has changed and you've done more due diligence, then I can see it. I can see that you've remembered you've got to do that for this new set of circumstances. But if nothing changes, how do I prove you've done it? How can I give you credit for doing it if I can't see it? And so this is where I, since, well, quite a long time now, I've been saying to firms, listen, you've got a problem here in evidence in ongoing monitoring. Here's what I would recommend you do. Just before you do the thing that could be money laundering, write yourself a little file note. It needs to be a couple of sentences to say that you're about to complete this transaction. You've got all your client due diligence in place and you're happy that everything's as it should be, nothing's changed, and you're happy to proceed. That's all you need. If something has changed, then you do need to investigate it. And please don't be lulled into that pressure that you've not got time to do the client due diligence, because I've seen that go spectacularly wrong in law firms, including a lawyer who was disciplined. I think she was suspended from practice. The law firm, her employers were able to show that they'd told the lawyer in training and in the policy, should something change last minute, you need to do client due diligence on it. She hadn't done that, and that's why she was disciplined and the firm wasn't. But the firm had to wait 2 years to find out if they were going to be disciplined, and that is not by Austrac or the equivalent. That was from their legal regulator. Because folks, breaking the law when it comes to AML, yes, there is a disciplinary process Austrac can come after you about, but for lawyers, we've also got this regulatory obligation that basically is, as lawyers, we follow the law, and if we're not following the law, then we should be expected to be dealt with through a disciplinary process, or if we break the law, disciplinary processes may follow from our regulator. And certainly in the UK, when we see people breaching our equivalent of your law, so our money laundering regulations, it isn't the police that are going after them. It is actually a criminal offence in the UK to not do this client due diligence properly. So it's not that bad here, but in the UK, it's 2 years in prison if you don't do it. I can count on one hand, the number of solicitors that I know have gone to prison for not doing the client due diligence. However, I think I just saw 2022's numbers. There were 23 firms, I think, that were dealt with formally, and 149 firms dealt with informally in the UK. That means fined for not regulatory fines for not complying with this legislation. So yeah, we all wonder about, are Austrac going to knock on the door and what are they going to do? They're not the only people you need to worry about when it comes to AML compliance. Okay, I promised you I'd talk about electronic verification. Can software help me with all this, Amy? That's what we want to know. We love software, and we're all in this kind of tech-enabled generation. As I say, I'm here in here in Australia, and I brought my daughter with me. and she's not a fan of the hot weather. We were talking about it before, right? So she doesn't want to go out. And so, you know, thank goodness for Uber Eats. That's what I say. Technology these days, you know, I expect everything to be really easy because of technology, and Uber Eats delivers me all kinds of stuff. It's amazing. So can we do this with technology? Yes, we can, is a quick answer. Some of it anyway, but it can't do everything. So, and the reason I've included this is, I did mention at the beginning, I imagine that you are being bombarded, or will start to be bombarded, with marketing from companies that say, you've got this big job to do and we can help you do it. And it's true, they can help you do it. But what I would just want to go through with you is, you need to be sure what it is you need the software to do, and then be able to ask the right questions of the suppliers to make sure it can do what you think it can do, because they're not all the same. A lot of them are the same, but they're not all the same. So generally, when you have somebody who says that they can have an electronic solution to help you with your client due diligence, so all these steps we've just been going through, there are three main activities that they will cover. Not all providers do all three. Some providers will only do one of them. So the first one is the ID&V. So you get the information and then they verify it for you for private individuals. So that is likely to look like checking various data sets like credit databases, or verifying the upload of a document. There's some nice, clever technology these days where a person can use the chip reader in their mobile phone to read the chip that's on the passport and get the data straight from there to reduce passport document fraud, stuff like that. So, and there's some really nifty, easy to use for your client software where, you know, they've got to do a liveness check, move their head around and stuff like that, make sure they're actually alive. That they can do that for you. And they will often use a combination of sources to do that, including, as I say, the liveness check, reading the chip on the passport, and looking at external databases to verify that what you've been told is true. Then you've got the ones that do ID&V for corporates. Now, some of the individual ones also do corporates, but some just do corporates. So corporates would be, they'll go off and they'll bring back for you all of the company registration documents that are available, and they might bring back lists of directors, lists of shareholders, and they sometimes, if they're in a combination with a company that does the personal ID, they might then, you might be able to press a button and then get the directors or the shareholders ID done through there. So corporate registries. There are some stuff that it's really difficult for them to be able to provide to you if it's not on a register that they can get access to, like trusts. So these software providers might not be able to fully solve the problem for you. It depends on your client base and what kind of clients you have. So particularly trusts are notoriously difficult. All companies from secrecy jurisdictions where it's difficult to get the documents, or the company simply leads you to something like a discretionary trust or something like that. So they can do stuff that's publicly available, can't get stuff that's not. So ID&V is the first function. The second one is PEP and sanction screening. So where you have a client who is a politically exposed person, which is a person or a close member of that person's family, because it extends to kind of secondary PEPs, that has a certain job, okay, a certain politically exposed role. The law says if you get one of those, you are going to have to do what's called enhanced due diligence. So before, when we were talking about getting proof of funds and asking about wealth, if you had a politically exposed person, the law would require you to get proof of wealth as well as proof of funds, for reasons that are very long to go into, but just suffice to say, you need to find out if any of your clients are PEPs. And so these searches will do that for you. When the client starts, they'll also run a check of their PEP register. Now, the register is not foolproof, because PEPs are the person with the job and close members of their family. So spouse, child, parent, child's spouse. they're the category of people, and people they're in business with. So if they own a company with someone, so I own Teal and AML Sorted with my husband. If I became a politically exposed person, I became a prime minister, as if, but if I became a prime minister, he would become a PEP because he's married to me. But even if he wasn't married to me, he owns a business with me, so that would make him a PEP. You can see that this list is difficult to collate, because how do we know who's somebody's children's spouses? How do we trace that? So these lists that they're using, the electronic verification providers, are commercially compiled by a provider. They're not foolproof. So, and you don't have to use one. You could just make inquiries of the client. Do you or anyone you know do these jobs? I mean, in a teeny tiny law firm I used to be the money laundering reporting officer for, that's what we did. We surveyed them and asked a question. We'd Google them and check they didn't come up on any searches as a PEP on Google, but we didn't pay for one of these fancy providers. That said, I've got massive firms that are opening thousands of matters a year. You probably do want to have an electronic solution for that. It does produce false positives, because lots of people in the world have the same name. So like if you PEP search my dad, he comes up as an Irish politician. He isn't an Irish politician, but he's got the same name as one. He's got a really common name. And so sometimes you get false positives. So then you'd have to contact the client and go, can you just confirm you don't do any of these jobs? And no one you know does either. So that's PEPs. Sanction screening. Now, sanctions, happily, there is a list of sanctions. For most jurisdictions, you're interested in your domestic sanctions, so the sanctions that Australia put on entities or people. And you're likely also to be interested in the American sanctions, and that's because money moves through the international banking system in dollars. It's all converted to dollars, moves, and then it converts back to local currency. So that means that the American sanctions have an extraterritorial risk, extraterritorial reach. So you not normally want to have regard to them. What am I talking about? A sanction basically will limit the sanctioned entity, the designated person's ability to spend their money, usually. And you can get in trouble if you help them do that. You make an economic advantage available to them. Every country's drafting is slightly different, but it basically boils down to the same thing. Don't help that person get hold of their money. The whole point of a sanction is to make that person inconvenienced, usually financially, so that it puts pressure on a regime to change what they're doing. That's what we see in the Russian sanctions, trying to encourage Putin to stop invading Ukraine by inconveniencing all of his rich Russian oligarch friends. So the checks will often come back with sanction results. Again, loads of false positives, lots of people have the same name, and you need to eliminate them. Then the third thing that they can do is negative news. Okay, now, I just was talking to a client in the UK a couple of weeks ago. They've just changed their electronic verification provider because they didn't feel that the news coverage of the one that they previously had was sufficient, and they wanted a wider news coverage. And I said to them, I was training them, and I said, well, also don't forget to Google them. They're like, what do you mean? We just changed provider to get this great negative news exposure. And I said, yeah, but the negative news, yes, it might have a search stream within Google itself and bring that back as part of your results. But you have no control over what they've searched for. So it might not bring back things like local news, depends how they've set their search up. I've had plenty of clients that have been able to detect, sadly, usually after it's become a problem rather than before it's become a problem. But I have had plenty of clients who've been able to detect that if they'd have Googled a client before they started working for them, they'd have never touched them in the first place. That's what I'm saying. They've become a problem before they found this out. But I have always recommended, even if you're not taking an electronic verification provider to provide you negative news, I would still Google any new client. I had one recently, was doing a property transaction with someone. The police rang them. They said, oh, we understand you're acting for Mr. Blogs. And my client said, I can't confirm or deny, it's confidential. He said, well, you don't need to confirm it. I've seen a letter that you wrote to them. But just so you know, he's been done for insurance fraud. And so I think the asset you're selling is been tainted by that mortgage, that insurance fraud, and is the proceeds of crime. And which opened up a whole world of pain for my client. Had to, figure out what he had to report, to figure out how he could continue. Would he upset the mortgage company? Loads of practical issues from that. And if he'd have just Googled the guy, he would have seen the conviction for the insurance fraud on the front page of Google. If you're not going to use electronic verification for that, I certainly would build into your process a quick Google of who this person is. Now, what can't they do? Often, it depends how they're set up, right? But some of the ways in which they work are just searching data sets without any context. So, for example, there are some searches out there that might not use document verification or the biometric check. They might just search the credit file. Less so now, as things have moved on and this technology has emerged for the biometric checks and all of that kind of stuff. But just be careful about the provider. What you want is a provider whose process is secure, really, and kind of prevents fraud. I said to you that my dad has got a name, very common Irish name. He's actually got the same name as his dad. And I came across this in practice once, not my dad, but a son and a father living at the same address with the same name. Now, if I search the name on one of the, like a credit file database or something like that, I'd come up with proof that someone with that name lives there, but how do I know which one it is? I was just auditing a firm recently. Their negative news had come up with somebody with the same name, and they'd gone, off and looking into it. So actually, it brought up the name of the dad, not their actual client. Oh, and they'd gone down a rabbit hole of thinking it was a pep, and the son, it wasn't him. You might say, oh, the son would be a pep, but anyway, for reasons I won't go into, it wasn't a pep anymore. So they can't necessarily be that accurate that the results that are coming back are definitely for your client. So you do sometimes, especially with PEP and sanction searches and negative news, you do just need to use some judgment on them. We just had a chat, didn't we, before we came on air about AI in this space. There are providers out there that are using AI to do things like filtering out false positives, things like that. But just be mindful that it doesn't necessarily, that search result might not tell you everything you need to know about that client from a know your client point of view. Can you use electronic systems for source of funds, source of wealth? In the UK yesterday afternoon in the UK, I did a webinar with a provider who taps straight into people's bank accounts and brings out the data and analyzes it and tells you whether anything's suspicious. I'm not aware of such a provider here yet, but certainly if source of funds, source of wealth goes the way that I said it might do, where you're expected to evidence it, there certainly that provider and some others may well think about coming over to Australia and using what's called open banking, so software that enables a provider to look straight into the bank account of a client rather than asking them to send you bank statements, which can be a faff, a bit of a pain to do. So software might come that might help you with the purpose and nature bit of it. So yeah, I think that's up to time, and that's everything I had. I know we've got a couple of questions that you wanted me to cover, which I'll do quickly.
Yes, we do, Amy. Thank you for that, by the way. So a couple of questions that came in, one being, do practitioners pass on the cost of the extra work required to comply with new requirements imposed on us?
So that's a really great question. Something about the cost. We need to wait for the guidance is my answer. I hate giving it depends or I'm not sure yet answer, but we're in a moving piece, it's still developing. And the reason that I say that is it shouldn't really be anyone's business what you charge your client to do stuff. You agree a contract with them. You're a provider. You decide the price, and you do pass that on. In the UK, for a while, we had a bit of inconvenient rules, essentially rules, that said you couldn't pass ordinary overheads on, and classified client due diligence activity as an ordinary overhead. We managed to kind of lobby and get that changed. So what you will see quite often is the cost of a search, if you use an electronic verification provider, passed on. The cost of often these providers will charge you a subscription to the service rather than a pay-as-you-go service. And so it can be quite difficult to definitely tell the client the disbursement value of it, because it's actually a big number divided by however many clients you have in that year, so you can't say for definite. So what I'll often see is that it'll be a separate line item underneath, like the professional cost, like the time. There'll be a separate line item for client due diligence. In my property purchase that I've just done, it was £75 for both of us to go through the process, including the source of funds, source of wealth stuff. It'd be quite common for me to see £15 to £20, so $30 to maybe $50 per person, added on to professional services, not as a disbursement, but as like part of the legal fees. It is something that I've raised with the Law Council and the law societies as I'm going around, and the regulators, that you know, this is a cost to the businesses, particularly those of you that are small. And you know, law is already not the most profitable of things at times. We're already quite stretched, and so to add this cost without us being able to recover it, you know, could be very difficult for a firm to do. So I have made that clear when I'm out and about, saying, can we just make sure we don't accidentally prevent firms from doing this? I haven't come across anyone who thinks that you shouldn't be able to do it. Where it gets a little bit trickier is where you want to do client due diligence, and everyone that comes, whether the law says you've got to or not. Again, whole other session on why that might be, why you might want to do that. But at least when you're doing it because you have to for the AML legislation, you've got a really clear reason and justification for making that additional charge to the client. When you're doing it because it makes it easier for your processing your admin, or you're managing your compliance, you don't have to do it, but you want to do it because you just want everyone to go through the same process, then that's a little bit harder to justify. But certainly I'm not aware of anything that would stop you doing that. It'd just be a case of you negotiating it with the client. What I often find, we used to find at the beginning in the UK, was this fear. We still hear it, you know, we'll lose that client to someone down the road because we've added this extra cost. I mean, in fairness, you've all got the same problem, so that client should experience this wherever they go. It shouldn't be that you're the only one charging. I'd be very surprised if that was the case. As I say, very common to see separate charges as legal charges for this on a bill.
Maybe one final question, just conscious of time as well. One of the registrants has asked, is family law, you know, out of scope, but could be interesting to answer on a broader spectrum?
Okay, so now actually I did a full session on this yesterday because it's a long answer. I'm going to say we're waiting for the guidance and the rules, and the reason for that is in the Act. So just if you're new to this, to let you know that there's an AML CTF Act 2006, and then that was amended by the AML CTF Amendment Act 2024. So what that did was it put new sections into the 2006, or amended the sections in the 2006 one. So that's where that's the legislation, the 2006 legislation. And it defines what a designated service is. It's in the schedule to 2024, but obviously it should really be in the 2006. And when you look at designated services, it's generally pointing to transactional work that you're doing. It's not intended to catch contentious work. Now, the reason I'm saying it depends is because I literally did a post about this on LinkedIn about 6 months ago, because some people were horrified at the suggestion that you wouldn't do client due diligence in family cases because there are transactions that are planned during a divorce, for example. So selling the matrimonial home is part of planning a transaction, and that might happen within the family law context, so that might bring you within scope. What we want is very clear guidance from AUSTRAC about the types of law that is in and the types of law that are out. For example, planning a transaction in the law, in your law, says it's in unless the transaction is as a result of a court order. So that would take family cases where there's a court order out again. Are you with me? Because it's very, it's a bit. I know their intention is to keep family out of it. They just have to make sure the drafting works. Yeah, I expect family will be out of scope. But don't tell any European regulators that. They'll be going nuts. They'll think they'll still do the CDD on it in Europe. So.
Oh, thank you, Amy. I've got a comment from Bernice here that just says a link to your books would be great. So I might just get you to send that across to me so I can include that in the follow-up email along with the link to the
no worries. And if you don't mind, if I could just say, I am running, if you've enjoyed what we've done today and you want some more in-depth, I'm doing another session for you, aren't I? We've got another one scheduled. Yeah. But I'm also doing like a 6-part program that is where we've got the time to go into some of this in a bit more depth, and it's completely free. We've just done week 3 of it. We'll be running it again from the beginning. So the best place to find me is on LinkedIn. If you're on LinkedIn, I'm sure you can provide my contact details, can't you, otherwise? But yeah, you're very welcome to sign up for those if you want some more detail on any of this.
Fantastic. We'll include that as well in the follow-up. And yes, we will definitely have you back tail end of the year. Hopefully once AUSTRAC releases some more of the guidelines and there's a little bit more clarity around what rules there will be I need to comply by. But just to wrap that off, thank you very much, Amy. Informative as usual. We had really, really good attendance. So definitely, you know, Australia's preparing for next year, and I look forward to speaking with you again in a couple of months.
Perfect. See you soon. Take care, everybody. Thanks for your time.
Thank you for attending, everyone.